Record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies to you for the late start, but we had some matters we had to get out of the way before we actually start with the arguments of the attorneys. However, we are now ready to commence. We are at that stage where the attorneys will have the opportunity to argue to you. And I should let you know that previously I had contemplated placing a time limit on the lawyers in their argument. Some of the factors that I considered in whether or not I should place a time limit on them was the quantity of the evidence that was produced, the conflicts in the testimony, and the complexity of the issues that you'll have to resolve. And after considering the length of the case and the nature of the evidence, I have decided not to place a time limit on the argument of the attorneys. However, I have placed upon each side a limit of no more than 2 attorneys may argue to you for this part of the trial. Now, the purpose of the argument by the attorneys is to discuss with you the facts and the evidence that have been presented to you, to discuss the law that I instructed you on earlier, and the attorneys may advance theories based upon the evidence, and they may urge conclusions that are fairly drawn from that evidence. However, during the course of their arguments, please remember my previous admonition to you that the comments and argument made to you by the attorneys are not evidence. All right? Having said that, Ms. Clark, on behalf of the people, are the prosecution prepared to proceed their opening argument?
Yes, Your Honor, we are.
All right, you may proceed.
Thank you very much. Good morning, ladies and gentlemen. Finally. I feel like it's been forever since I've talked to you. It kind of has. It's very weird to be in this courtroom next to you, seeing you every day, not getting a chance to talk to you. It's just very unnatural. And I have to tell you that as long as I've been doing this, as many years as I've been doing this, at this moment in a trial, I always feel the same. I feel like I want to sit down with you and say, what do you want to talk about? Tell me what you're thinking.
Ms. Clark, I'm sorry.
You want a pen, sir?
Juror 165 needs a pen. Ms. Clark.
Thank you, sir. I want to sit down. I want to talk to you. I want you to tell me, what do you want to know? You know, what do you want to talk about? Because that way I don't have to talk about stuff that you don't need to hear, stuff that you don't want explained, stuff that you're not interested in. And I can't. And I always have this sense of frustration. So I'm sorry if I say things that you don't need to hear or explain things that are already very clear to you. Please bear with me because I'm not a mind reader and I don't know. Let me first, I want to take this opportunity to thank you. And I want to thank you from the bottom of my heart. You have been through so much. You have made a tremendous sacrifice. You haven't seen your children enough. You haven't seen your family enough. You haven't seen your loved ones enough. And all of this in the name of justice, in the service of justice. Your dedication and your selflessness are truly beyond the pale. No one can say that any jury has sacrificed more for the cause of justice than you have. And I want you to know sincerely from my heart, I appreciate it. I speak on behalf, I know, of the people of the state of California. This was a tremendous sacrifice. Your selflessness and your devotion will long be remembered by many. And I thank you. I think no one can understand how great your sacrifice has been, how terrible the pressure has been, how awful it must be for you to have your lives kind of out of control this way, at the mercy of us taking longer than we should have, and you having to put your lives aside for longer than you should have had to do. I'm sorry for that. I apologize for that. There's only one bright side, 2 bright sides. One, it's almost over. Number 2, you have the assurance of knowing that no stone has been left unturned. The defense has explored every nook and cranny of the case. We have exhaustively tried to give you every piece of information that could possibly be relevant to answer the question we're here to answer. And in doing so, in the exhaustive examination and cross-examination of all of the witnesses in this case, and the exhaustive investigation and work that's been done, one thing is clear. This defendant has received the ultimate in a fair trial. And at least you know that. You have that assurance. Now, in the course of presenting all of this evidence, in this trial, just like every trial, some evidence has been presented to you that really is not relevant to answer the core question of who murdered Ron Goldman and Nicole Brown. And it's up to you, the jury, to weed out the distractions, weed out the sideshows, and determine what evidence is it that really helps me answer this question. And it's kind of like the artist, the sculptor. Somebody went to him and said, well, how do you make an angel? Well, I take a piece of marble and I remove everything that's not an angel. That's what you have to do. It's not easy. It's going to require a lot of focus and a lot of determination on your part, because the sideshows may be very interesting. They present very important issues, very serious issues, but issues that really do not relate to who committed these murders. And they should be dealt with outside this courtroom, because here now, in this courtroom, we're here to decide who murdered Ronald Goldman and Nicole Brown. Now, you as jurors sit as judges of the evidence. You're called the trier of fact. And as such, your job it is to be neutral and to be impartial as you examine the testimony presented. And in this regard, you're guided, just like any judge, by the law. And the jury instructions that were read to you on Friday is the law that you will apply to the evidence to determine the answers to the question that is posed here. Who murdered Ronald Goldman and Nicole Brown? The instructions discuss a wide range of topics. They talk about guidelines for the determination of credibility of witnesses, both expert and lay witnesses, and they talk about what the people are required to prove to establish the defendant's guilt. But they go beyond that, and they also tell you the frame of mind that you should adopt when you look at all the evidence. And one of the first instructions that was read to you by the judge on Friday, if you'll recall, concerned your duties as a jury, and it stated in part, you must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. Now, of course, that makes sense. It's logical. And that means that we have to present proof to you. We can't just come in and say it's so. Why don't just get up here and say it's so? I have to prove it to you with evidence beyond a reasonable doubt. So that makes sense. Now, the instruction goes on to read, you must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. In the course of this trial, you have heard some testimony of a very emotional nature. I expect that in the course of arguments, you're going to hear very impassioned speeches, fiery speeches, speeches that may stir up feelings of anger, sorrow, pity. Although your feelings may be aroused, as would be natural and understandable for all of us. As the instruction tells you, as the trier of fact, you, the judges, are to remain neutral and impartial and not be influenced by such passion or sentiment, no matter how sorely tempted you may be to do so. And this applies to both sides, both sides. Although the brutal and callous way in which Ron and Nicole were murdered may understandably make you feel sorrow, pity, even anger, it would be wrong to find the defendant guilty just because you felt sorry for them. On the other hand, although it would be completely understandable if you were to feel angry and disgusted with Mark Furman, as we all are, still it would be wrong to find the defendant guilty, not guilty, just because of that anger and disgust. So as you listen to the arguments of counsel, please remember, when you weigh the evidence and you consider all of the evidence, remember that an appeal to passion and emotion is an invitation to ignore your responsibility as a juror. To be fair, we must examine all of the evidence in a calm and a rational and a logical way. And let me come back to Mark Furman for a minute, just so it's clear. Did he lie when he testified here in this courtroom saying that he did not use racial epithets in the last 10 years? Yes. Is he a racist? Yes. Is he the worst LAPD has to offer? Yes. Do we wish that this person was never hired by LAPD? Yes. Should LAPD have ever hired him? No. Should such a person be a police officer? No. In fact, do we wish there were no such person on the planet? Yes. But the fact that Mark Furman is a racist and lied about it on the witness stand does not mean that we haven't proven the defendant guilty beyond a reasonable doubt. And it would be a tragedy if, with such overwhelming evidence, ladies and gentlemen, as we have presented to you, you found the defendant not guilty, in spite of all that, because of the racist attitudes of one police officer. It is your duty, and it will be your challenge, to stay focused on the question you were brought here to answer. And the only question that you were brought here to answer: did the defendant commit these murders? In seeking the answer to this question, you look to all of the evidence presented to you by both sides now, by both the people and by the defense. And you determine what evidence really answers that question. Because the defense has thrown out many, many other questions. They throw out questions about whether LAPD has some bad police officers. Does the scientific division have some sloppy criminalists? Does the coroner's office have some sloppy coroners? And the answer to all these questions is sure. Yes, they do. That's not news to you. I'm sure it wasn't a big surprise to you. But those are not, they're important issues. You know, we should look into the quality control. Things should be done better. Things could always be done better in every case, at every time. There's no question about that. We're not here to vote on that today. The question is what the evidence that was presented to you that relates to who killed Ron and Nicole, what does that tell you? Does that convince you beyond a reasonable doubt? No matter how much more qualified or how much better they could have done their job, still in all, did they present enough evidence to you? Did the evidence come to you in sufficient quantity and convincing force to convince you that the defendant committed these murders beyond a reasonable doubt? Ladies and gentlemen, I submit to you that we have more than met our burden in this case. Now, the defense has thrown out a lot of possibilities to you, the merest of possibilities. And a lot of them were just there to scare you. You heard Dr. Gerdes talk about it could be this, it could have been that. I see the validation studies, you know, kind of like, it reminds me of the doctor when you have to go in for an operation, they give you all this list of things that could possibly happen to you, Nevertheless, and they have to give you that warning, right? They got to tell you that, because otherwise you cannot give an informed consent and say, yes, knowing the risk, I'm going to go and do this. Now, if you really believed that all these horrible things were going to happen, no one had an operation. You wouldn't take the risk. But you know, they've got to tell me everything, no matter how remote the possibility. And indeed, you go and you have the operation, and you're fine. And none of that stuff happens. Well, in this case, it's actually, they've raised all the possibilities of things that could happen in an effort to scare you away from the evidence. But we have done better than you could ever do in an operation, because we have proven to you that nothing in this case did happen. We have proven to you that it was not contaminated. We have even proven to you that it was not planted, for lack of a better term. And I'm going to go through the evidence and demonstrate how we have proven that to you. So why were these issues raised? Why were these questions raised? Well, they are all questions and issues that were raised as a distraction. They were roads created by the defense to lead you away from the core truth and the issue that we're searching for the answer to, which is who murdered Ron and Nicole. But these roads, ladies and gentlemen, these are false roads. They're false roads because they lead to a dead end. The false roads were paved with inflammatory distractions, but even after all their tireless efforts, the evidence stands strong and powerful to prove to you the defendant's guilt. Now, I'd like to show you a jury instruction that is very important. I think that both the prosecution and the defense will agree. May I approach a moment?
Thank you. Proceed.
Thank you, Your Honor. Reasonable doubt. Okay, this is an instruction that we'll talk to you about, they're going to talk to you about. This is a real important instruction. It's at the real heart of a case, every criminal case, because it's the burden of proof that the people have. We don't guess anybody guilty. We prove it beyond a reasonable doubt, which is what we've done in this case. Now, this tells you about reasonable doubt. It's kind of a funny definition because it talks to you about reasonable doubt in very negative terms. It says that state of the evidence, which after the entire comparison, you cannot say that you have an abiding conviction. It's very weirdly worded. It's going to take you a while to go through this. So I'm going to go through pieces of it at a time to try and give you a little hand here. First of all, let me point out the first paragraph talks about the fact that it's our burden of proof. I think that one's fine. That's pretty easy. Now it talks about how reasonable doubt is defined. This is real important. It is not a mere possible doubt, okay? Because everything relating to human affairs is open to some possible or imaginary doubt. That's very important. It's a doubt founded in reason. I'm going to amplify more on that with examples when we talk about the actual evidence in this case. But bear that in mind, a possible doubt. I have a possible doubt that the sun will come up tomorrow. Do I have a reasonable doubt about it? No. I have no doubt founded in reason that that's going to happen. Just for a very basic example. So think about that, too. We're not talking about what possible doubt is. It's reasonable doubt. Now, the other part of it, it is that state of the case which, after entire comparison, the entire comparison and consideration of all of the evidence. Now, what that means, ladies and gentlemen, is you consider the defense case and you consider the prosecution case. You consider all of it. You'll probably hear from the defense multiple times, we don't have to prove anything. That's right, they don't. In every criminal case, when the people complete their presentation, the defense can say, no witnesses. We rest. Because they can sit and make the state prove their case without ever calling a witness. That's right. That's correct. But when they do, then you must consider the quality and the nature of the evidence that they have presented. That goes into the mix. That's part of your consideration. What kind of evidence did they present to demonstrate something to you, to prove something to you? If they try to prove something to you, their witnesses, their evidence gets evaluated by the same rules ours do. The same jury instruction applies. You will see a jury instruction in your packet back there that talks about how to evaluate the credibility of witnesses, both expert and lay witnesses. There is no distinction made in that jury instruction for defense witnesses or for people's witnesses. It's all the same. You determine their credibility and the relative convincing force of the proof by the same rules, okay? So that's the first thing to remember. When you look at everything, you look at all of it. What have they shown you? What have we shown you? We have the burden of proof, but you look at what they've shown you when you want to consider what was proven to you. We got pieces of boards and exhibits everywhere in this courtroom. All right, now, all I'm telling you, ladies and gentlemen, is it's reasonable doubt and it's not possible doubt, and we'll come back to it again. But at the conclusion of all of our arguments, when you open up the windows and let the cool air blow out the smoke screen that's been created by the defense with the cool wind of reason, you will see that the defendant has been proven guilty easily beyond a reasonable doubt. Or to put it another way, the evidence has conclusively proven that when Detective Mark Furman said he did not use racial epithets in the last 10 years, he lied. But it has also conclusively proven that the defendant is guilty beyond a reasonable doubt. Now, I'd like to start with the evidence in this case with the timing, okay? I think that's the easiest place to start. The timing on June the 12th. Let's begin with a very brief review of the movements of Ron and Nicole, and we're going to start with the recital in the late afternoon. I'm sure you recall that recital for Sydney at Paul Revere High School. Nicole left the recital and went to the Mezzaluna restaurant near her home along with her parents and some friends and her children, Sydney and Justin. And she arrived at the Mezzaluna at approximately, I think it was 6:30 p.m. Ron Goldman, who was an acquaintance of hers, a waiter at the Mezzaluna, was working that night but did not wait on her table. And when Nicole and her family left between 8:30 and 9, they didn't know that the simple act of dropping a pair of glasses would have the tragic consequences that we all know now that it did. Now, you recall at the end of the People's case there was a stipulation that we entered into, and you recall that the judges told you that a stipulation is to be accepted by you as an undisputed fact. And the stipulation told you the following. After leaving the Mezzaluna that night, Nicole's mother called the Mezzaluna to ask about her glasses. That was at 9:37. Karen Crawford, the bartender and Sunday night manager of the Mezzaluna, took the call and went out to look for the glasses. She found them outside near where Nicole had pulled up in front of the restaurant, and at Mrs. Brown's request, she put the glasses into an envelope on which she wrote, I believe she wrote, Nicole Simpson will pick up Monday. That call lasted 2 minutes. It was also stipulated that at 9:40 p.m., Mrs. Brown called her daughter Nicole, and they spoke for 2 minutes. And in that last conversation, before her death, Nicole promised her mother that she would arrange to pick up the glasses. Now, those two conversations with Nicole's mother were a matter of stipulation. That's an undisputed fact. Karen Crawford testified that about 5 minutes after speaking to Nicole's mother, she got a call from Nicole. That would mean Nicole called her at about 9:43. Nicole asked to speak to Ron. He took the phone, and after Ron spoke to her, he asked Karen for the glasses, and she gave him that envelope containing the glasses. And at about 9:50, 10 of 10 that night, Ronald Goldman left the Mezzaluna restaurant. When he left, he was wearing the white shirt and dark pants that were part of his waiter's uniform. And that uniform was later found by his sister, Kim Goldman, in his apartment, draped over the bedroom door. That uniform is here in evidence. So we know that Ron went home and changed clothes after he left the Mezzaluna at about 9:50. The other waitress in the restaurant, Tia Gavin, testified that it takes about a minute to walk from the Mezzaluna to his apartment. So, even being a little generous, he got home by about 9:52, say. He changed, he freshened up, because we know he wasn't wearing that waiter's uniform when he was found. And so it would be reasonable to infer that he got to Nicole's house with the envelope sometime shortly after 10. And when I say sometime shortly after 10, we don't know exactly what time, and I'm not saying that we do, but 10:10 or so would seem a reasonable amount of time to get freshened up, changed, and get over there, based on what we do know. Now that brings me to something else that I want to point out. In the case, as in every case, there is certain evidence that is introduced that is directly proving a fact. For example, in this case, Ron Goldman left Mezzaluna at approximately 9:50. It's approximate time. Could have been a few minutes later. So we know that sometime before 10 he left. We know he changed clothes, okay? But the direct thing we know is that sometime shortly before 10 he left. We know he changed clothes because he was wearing something different when he was found. We know how long it takes for him to get home because we have a witness telling us that, but we don't know is exactly what time he left his house. We know he left his house in time to be murdered, and we'll talk about that shortly. And in time for him to be there with the dogs barking, we have to make inferences. Okay, we have to make an inference from the evidence that we know about as to when he got to Bundy. Now, you can draw an inference that is reasonable, or you can draw an inference that is unreasonable. What we are required to do here, and what I must do, is draw inferences that are reasonable, based on what we know when he left the Mezzaluna, changing clothes, freshening up, and I think Stuart Tanner testified that they had plans to meet at the Baja Cantina. He was going to get cleaned up to go somewhere. It's reasonable then to infer that he took 10 minutes or so to do that, change clothes, freshen up, and then go over to Bundy. Now, the dogs. Excuse me, the witnesses that testified to the dog. As you may recall, we heard from a number of them, and they were neighbors of Nicole. Now, as for the people that the prosecution presented on this issue, all of these people were people who lived very close by. All of them were people who were home on that night, and all of these were people who were not distracted by anything else going on at the time. And all of these were people who did not seek out involvement in this case. All of these were people who were found by the police during normal police procedures as they went knocking around the neighborhood doors to find out if anybody heard or saw anything. And some of these people were disturbed by the police at 2:30 in the morning, at 5 in the morning, and these people just were summoned by the police to tell what they heard, what they saw. They didn't go out looking for their 15 minutes of fame. They didn't go calling the police and running after the detectives to try and tell them they knew something important so they could be on TV and become the latest sensation. These people were called upon by the police because they were there. They were near her. They were close to the condominium. They were within range where they might have seen or heard something, and so they were contacted. And so they were subpoenaed. They didn't ask to be involved. And that's a big distinction between our witnesses and the witnesses called by the defense on this issue. Now, the significance of the barking dog is obviously that it tells us roughly when the murders occurred. Not exactly, but it's reasonable to infer, again, reasonable inference, that the murders occurred either shortly before or during the time when the dog was barking. Now, the neighbors who testified to this said that they had not heard a dog barking so insistently like that before. It really drew their attention. That's why they remembered it. It's why it woke them up or disturbed them or made them concerned, made them look out their windows to see what was going on, because it was unusual. Which means that Nicole was not in the habit of letting her dog run around like that. Which means that if that dog is barking like that and she's not tending to it, she's already dead. Now, what did they say? The witnesses that we presented were very consistent in this regard. I'm going to show you
All right, Mr. Escobar, would you just briefly display that to defense counsel so they know which one it is we're looking at? All right, it's a timeline board. All right, proceed. Thank you, Mr. Escobar. And we may have a problem with the court reporter. It's timeline board. I just had him show it to you, counsel. Do you have a small copy of this? All right.
We're reading out small copies. Can counsel?
All right. Why don't you proceed with your argument at this point? Let's compromise. Move it over here so we can all
Move it
see
up
it. Mr. Escobar, Mr. Wooden, would you move this back over to the standard position, please?
Aren't going to be able to see it so well for now. We'll move it back down in just a little bit. Okay.
All right,
Everybody see it?
1386, can you see that? 165, can you see that? All right, thank you very much. Ms. Clark.
Okay. All right. Now I'm going to direct your attention down here. Okay. The first witness that we called was named Pablo Fendes. You may recall that he testified he was in his apartment on that night, and that at approximately 10:15 to 10:20, he heard the insistent barking of a dog. He called it a plaintive wail. And the nature and sound of the barking that he heard made it sound to him like it was a dog in trouble, like something traumatic had occurred. And it drew his attention, made him think about what was happening, and he noticed it. He noticed it, and he noticed the time because he'd been watching the news. And so he tied the time to that event. And he testified it was between 10:15 and 10:20, approximately, that he heard that. We called also, and you see he's right here on the timeline. Mark Storfer testified as well. Now, let me back up, I'm sorry. Pablo Fenves was the one who lived behind the condominium, diagonally behind Nicole Brown, across the alley, if you'll recall. His windows, he had windows that faced the alley, and at one point I think he pointed out where he was able to see. And he indicated that the barking seemed to come from the location of Nicole's condo. So he lived right behind her. The other witness who testified was Mark Storfer. Mark Storfer lived down on Dorothy. That would have been just south of Nicole's condominium. Mr. Fairlew, do we have the dog board that we had showed with the witnesses where they lived? Is that down here? Oh, I'll get it. That's fine. That's fine. We used it during the presentation of the testimony. I think it really makes it a lot easier to remember the locations and figure out where people are in relation to each other if you can see that board. And then I won't have to explain so much. That's great. Thanks.
Ms. Clark, this is People's Exhibit.
People's Exhibit 26, Your Honor.
Thank you.
Thank you. All right. Here, the red house here that I'm pointing to is Nicole Brown's house. This purple house right here, south on Dorothy, that is Mark Storfer's house. And he testified, if you may recall, that he was just putting his little son to bed when he heard the dog barking. And he was concerned, and it drew his attention because he was worried that the dog was going to wake up his son. You know, I think a lot of us know what that's like. You finally get the baby to bed, and then something happens to wake it up. It's horrible. And that's what happened to him. So he was very cognizant. He was very aware of the fact that dog was barking, and it was disturbing him. He went upstairs, and approximately, he said, 2 to 3 minutes after he heard the dog start to bark, went up and looked at his clock because he was concerned how late the hour was and why the barking was so loud at that late hour. He looked, and he looked at his clock, and it said 10:28. Now, he said they always keep their clocks 5 minutes fast. So his clock really, this gets complicated, really said 10:23. Since he heard the dog start barking 2 to 3 minutes before he looked at the clock, it was approximately 10:20 to 10:21. Now, he also lived very close. And what's important for you to know and recall about his testimony is that when the dog started barking, he indicated that he looked, he indicated that he looked out his window at 10:23. A few minutes after the dog started barking, he went to see what was going on. And the source of the noise seemed to come from north of him on Bundy, which is, of course, the direction of Nicole's house. And when he looked out the window at 10:23, he saw no one walking down the street. That's real important. I'd like to ask you to try and remember that fact. Mr. Darden will discuss how significant that is when he speaks to you later. We also heard from Eva Stein and Louis Karp. They were the next-door neighbors of Nicole Brown. This is the blue house here. They live right next door. Now, on that night, Eva Stein had gone to bed shortly before 10 o'clock. And at some point, she indicated shortly after she fell asleep, she was awakened by the loud, insistent barking of a dog. Or she thought it might even been more than one dog because it was so loud. She indicated that shortly after that, approximately half hour later, after she started to hear the barking dog, her boyfriend, Louis Karp, came home. And she could tell that he came home because she heard the bell. So half hour after she heard the dog barking, he came home. And Louis Karp told you he came home at 10:45, 10:50 at the latest, which means that she heard the dog barking also at 10:15 to 10:20. Now, And just to remind you, Pablo Fenbez's house is the yellow one indicated here on the board. So just across the alley behind Ms. Brown's condo. All right, now, Louis Karp also told you something else. He told you that when he came home, he went into his garage, and then he went out in front to get the mail. And when he went out in front to get the mail, he saw a dog in the street. And this was the time he indicated that he got home. When he got outside, he saw a dog running around in the street, barking insistently, a dog that he identified for you as Kato, Nicole's dog. The dog was prancing around in the street and acting in a very weird manner, and Mr. Karp was a little afraid of him and went back inside. Now, Mr. Karp also told you that he saw a man walking a dog. Steve Schwab told you that at about 10:30 he left his home and went out and took his dog for a walk. If you recall, he said that he waited to see the end of the Dick Van Dyke Show and then went out to walk his dog. That was about a little after 10:30. He told you of the route that he took, walking around the neighborhood, and he told you that at approximately 10:55, he saw Kato, Nicole's dog, at the corner of Dorothy and Bundy. And he told you that the dog was acting very strangely. So he went over to look at the dog, and when he did, he noticed that the dog had blood on its back paw, and the blood appeared to be moist. He crossed over to the east side of Bundy where he said the lighting was better. In other words, saying to you that the side of the street that Nicole lived on was poorly lit. Now, he noticed that the dog's paws had blood on it, but he did not testify that he saw any paw prints on the sidewalk. Does that mean that they weren't there? No. It means he didn't notice them. Obviously, if the dog had blood on its paw and it had gone out of Nicole's home and it had walked down the sidewalk, there were paw prints there to be seen. The fact that someone doesn't see something doesn't mean it isn't there. It means they didn't see it. That's what I mean about reasonable inferences to be drawn from the evidence. Now, when he crossed over to the east side of Bundy where they had more light, the dog stayed with Steve. He stayed and they continued to walk. But as they walked, at each house that there was a pathway, the dog stopped and barked, looking up the pathway. This dog was acting very strangely. Obviously, it had seen a very traumatic event. Whether it actually witnessed the murders or simply came up on the bloody aftermath, it's clear the dog saw something. Now, when Steve got home, he took the dog into his courtyard, and he was able to see that there was blood on the underside of the belly, and there was blood on all four paws. But the dog was not injured. Now, Steve's friend, Sukru Bostepi, if you recall, he was the one who found the bodies. Sukru agreed to take the dog from Steve for the night. And when you recall that when he took him into his apartment, the dog was acting so agitated and so nervous that he had to take it out for a walk, and he decided to let it lead him, perhaps lead him to where it lived. And the dog did lead him. The dog pulled. The dog pulled, and as they went south on Bundy, the dog pulled harder and harder. And as they walked south on Bundy towards Nicole's home, when it got to the pathway that led up to Nicole's house, the dog stopped. And it looked up the pathway. And Sukru told you that had the dog not done that, he would not have looked up the pathway, and he would not have seen what he saw. But as it was, he did. And because he followed that dog's gaze, he saw a sight, probably the most horrifying one ever seen in his life, or hopefully ever will see. Now, Sukru told you that when he saw Nicole Brown lying on the ground, it was midnight. So we know that the murders occurred after 10 and before midnight. That's the window that we know we have just based on what people observed and what people saw. Now I'd like to turn to the defendant's activities for that night, and I'm going to show you how during the time period preceding the barking, during the barking, and for over half an hour after the barking, the defendant's whereabouts are unaccounted for. Let's start with Kato. Kato was a necessary witness for us to call, but he was by no means a witness who was happy to testify for the prosecution, as you could tell. This was the defendant's house guest, someone who started out as Nicole's friend and boarder, who found a better deal, certainly a cheaper deal, at the defendant's estate. You'll recall that he met Nicole after her divorce back in 1992 in Aspen. And when he went to a party at her house on Gretna Green in during 1993 or the end of 1992, he asked if he could rent the guest house on that property, and she agreed. And they made an arrangement that he would pay monthly rent and reduce that monthly rent to some extent by performing babysitting activities for her 2 children. Now, he lived there with her in Gretna Green for almost a year, filling in as babysitter for the children, a friend to her, and the children as well. But when Nicole moved in January of 1994 to Bundy, there was no separate home for him to live in, no separate guest house, and the defendant asked him not to go and move in with her. And he persuaded Kato to go and live with him at Rockingham for free. That was a very good deal for Kato. As you may recall, I even asked him, how much money did that save you? You know, to stay in a place like the defendant offered him, with the availability of the pool and the jacuzzi, tennis court, living on that estate in kind of like a studio apartment, probably would have cost him $600 a month. Or what did he say? I think we wound up estimating that the total amount of money he saved staying there for free was about $6,000. He was very indebted to the defendant. And the aspiring, but none too successful at that point, actor Kato saw also a career-wise move that was very good for him, because in the defendant he could have a connection. Get the picture here. Logically speaking, this man is indebted to Mr. Simpson. And he was not a happy camper to be a prosecution witness. And he certainly didn't want to come in here and give testimony that might prove damaging to him. And you could tell from his demeanor, I'm sure, that he was not about to volunteer anything he didn't absolutely have to tell us unless he was cornered. I don't know whether you remember it now. It's really been a very long time. But during his testimony, I brought out the fact that at the grand jury proceedings back in June of '94, I asked him whether he'd ever witnessed any fights between the defendant and Nicole. And when he was asked in front of the grand jury whether he ever remembered seeing them fight, he answered that he remembered only one. And I asked him, do you remember anything about the nature of that fight? And he said, no, only that it was one. Only that it was one. And then when he came into court here, ladies and gentlemen, when I asked him why he didn't bring, we asked him what he meant by that one fight that he had witnessed. That was the 1993 call to Gretna Green that you heard on tape when Nicole Brown called 911 and the defendant was standing outside screaming, yelling obscenities at her, and broke the door down, and she was afraid for her life. That was the fight he was talking about. When he answered to me in the grand jury, I remember one fight, and I only remember that it was one. Now, when he gave that vague, almost meaningless answer, no one at that time knew about the 911 tapes, and so he could get away with it until that became a matter of public record, and we all found out. And I couldn't confront him with that because I didn't know about it. And that's how he slid around and would have continued had it not been brought to our attention by other means. But you see, so at that time, he was safe. But when he got called on it, and you realize how only that it was one, and he's talking about that event, that gives you a sense of how much he wants to help Mr. Simpson. Now, although on June the 20th, when he was directly asked under oath about the past relationship of violence between the defendant and Nicole, he said almost nothing, as I've indicated to you. And when he was interviewed by Mr. Shapiro, 6 days before that, he was a lot more forthcoming. When he was interviewed by Mr. Shapiro, as I pointed out during his testimony, he brought out the 1993 Gretna Green incident. He brought out the fight at the Jenner's Christmas party in 1993. But when I asked him 1 week later, when he was under oath in front of the grand jury, I remember only one fight, only that it was one. Very different demeanor between the time that he spoke to me in front of the grand jury and the time that he spoke to Mr. Shapiro 1 week earlier. And doesn't that alone tell you how reluctant a witness he was for the prosecution and how much he identified himself and wanted to identify himself with the defendant's side? Now, after he spoke to the police, though, this is the position he finds himself in, so you know, so you understand why he had to come here and give the testimony he did. At the time he spoke to the police in the early morning hours of June the 13th, he didn't know that what he was giving was damaging evidence against the defendant. He only knew he heard thumps on his wall. That's all he knew. And the events that transpired that night. He knew they went out to McDonald's. He knew that they had gone through all the things that I'll point out later for you, but they went to McDonald's, they had a burger, they came back. He went to his guest house. Mr. Simpson stayed outside. He later heard thumps on the wall during a phone call. At that point, he didn't know the significance of what he was saying. And he would surely never have told the police any of those things had he known what they meant. And so the problem was that once he told the police what had happened that night, he was stuck. He couldn't go back on his word. He had given them a detailed statement. It wasn't like he had given something vague that he could slide around with. He gave a very lengthy, detailed statement to the police because he was telling the truth. He didn't know any better than to tell the truth. And so when he was called back before the grand jury, at the preliminary hearing and at this trial, he had to recount that same truth. And he had to tell you. He had to tell you. Now back to the timing. Kato told us that he was on the phone with a friend when the defendant came out to the pool area near his door. And he was able to pinpoint that time with the phone call bill that he had, because the phone call was a long-distance call. Now, the call was placed at 9:03, and it lasted for 7 minutes. And when he saw the defendant come out to talk to him, he hung up the phone. So it was about 10 after 9. I think we do. At 10 after 9, approximately, and just so we have 9:10 here, maybe it was 9:09, the defendant came out to talk to Kato. This is a very, very significant conversation that they have. I'm going to come back to this a couple of times. So here's the first time. The defendant told Kato that he had only $100 bills on him. And he asked Kato if he had any fives for the sky cap. You may recall that. Asked him if he had fives. Kato went to look, and he realized he only had $20 bills. So he gave the defendant a $20 bill, which the defendant took. Then the defendant told Kato he was going out to get something to eat. He didn't invite Kato. Kato invited himself. Now, I remember when I heard that, I thought, what's wrong with this picture? This doesn't fit. If you're going out to eat and you only have hundreds, you need change, you're going to break that 100 when you go out to eat. Why do you have to ask Kato for fives? You've only got hundreds. Wherever you go, you can break it if you're going out already anyhow. So what's the point here? Now, keep that thought in mind, because I'm going to come back to that. That's very significant. All right, that was at about 9:10. They left immediately, and they drove to McDonald's in the defendant's Bentley. Did it strike you as odd that he'd take a Bentley to a drive-through to the McDonald's when he's got a Bronco? It's not like there's no other car. Now, you've seen the picture of the defendant taken at the recital for his daughter, Sydney, earlier that night. And in that photograph, he's wearing black dress slacks and like a white polo-type shirt and a black, looks like a shirt to me because you can see the seams in the sleeve and a collar to it with the sleeves rolled up. But Kato told you that at the time he saw the defendant, at approximately 10 after 9, The defendant was wearing a dark blue or black cotton sweat outfit that had long sleeves. So after the recital, the defendant changed clothes. And that's important too. I'll come back to that. Kato had several occasions to notice the defendant's hands during the drive to McDonald's, and during the time that they paid, and during the time they got change, and he noticed that there were no cuts on the defendant's hands. Or he didn't notice any cuts on the defendant's hands, to be more accurate. And that's actually an important distinction. You'll notice too, though, when you look at the photograph of the defendant in the recital, you can see his left hand. And you can see that as of the time of the recital, when he's posing with Sidney, there's no cut on the back of the middle finger of the left hand. And that's important. Now, what's probably even more significant than Kato's lack of observation of any cuts on the defendant's hand when they're at the drive-through lane is this. Kato wound up paying for the food with his own money, paid for both of them. He handed the defendant the money, the defendant paid, defendant got change back, and gave it to Kato. Gave it to Kato. Wasn't the whole point of talking to Kato to get change for the sky cap, get fives for the sky cap? Okay, now you have another inconsistency here. First of all, he asked Kato to give him change when he's going out already, he can get it himself. Secondly, he has the opportunity to get change right there at the drive-through window, either take Kato's or break the 20 that Kato gave him, and he doesn't take that opportunity. That's important too. I'll come back to it. They returned to Rockingham, and Kato proceeded, wanted to indicate, when they returned during the ride home, the defendant wolfed his food down while he was driving. Kato saved his. And all of these facts are going to be tied in at the end of this presentation. So I ask for your patience. Bear with me. I want to stick with the timing right now so I don't get distracted. When they got back to Rockingham, Kato got out and he walked towards the house, expecting the defendant to follow him. But when he got to the front door, he turned and he realized he's not here. And he saw the defendant still standing by the Bentley, watching him. And he had not moved. So as Kato told you, he took the hint, turned and went to his room. Now, why didn't the defendant just walk in the house? Or, if he intended to go somewhere, why didn't he just get back in the car and go? Either in the Bentley or in the Bronco. Why wait for Kato to be out of sight? I'll come back to it. Let's think about it for a minute. Now, as soon as Kato got back to his room, he called a friend, and fortunately the friend lived far enough away that it was a long-distance call, so we have his phone bill that indicates what time it was. And he indicated that he made that call as soon as he got back to his room. So the call was made at 9:37. So he left the defendant's presence at 9:36. And you can see here, at 9:36, the defendant was last seen standing in the driveway. From 9:36 until 10:54, the defendant's whereabouts were unaccounted for. So we have the beginning of our window of opportunity at 9:36. Okay, now I'd like to remind you of some testimony you heard about the Bronco. Back up for just a minute, talk about the car. Kato said the defendant almost always parked the Bronco on Ashford. And when I asked him when, during the 6 months that he lived there, he could remember ever seeing it parked on Rockingham, he said that he couldn't come up with any answer. I did ask him if he'd seen the Bronco either when they left the house to go to McDonald's or came back, and he indicated that he didn't notice either way. He wasn't looking for the Bronco. But there was a witness who was out on Rockingham that night. He was out walking his dog between 9:30 and 9:45. That witness was Charles Kael. He was a neighbor of the defendant's. And when he was walking his dog, he was a neighbor of the defendant's, he knew where the defendant lived. And I think he indicated that he had even been on Mr. Simpson's property at some point. So he was walking his dog that night between 9:30 and 9:45. And as he did so, he walked down Rockingham. And he looked, and he could see, I think he indicated it was 60 yards away, but he could see, that'd be 180 feet, that there was no Bronco parked on Rockingham when he was walking his dog, approximately between 9:30 and 9:45. Now, there are two inferences we can draw from this. Either one is reasonable. Either the Bronco was on Ashford, which is why he didn't see it on Rockingham, or Mr. Simpson had already left in the Bronco by the time he walked his dog. Now, Mr. Kael also indicated that when he left his home on June the 13th at 7 a.m., when he drove down Rockingham, he did see the Bronco. And you notice it was parked at kind of a funny angle to the curb. Now, what that tells us then, let's adopt, well, we have two reasonable inferences, and I'm going to talk to you about this a little bit later. We have a jury instruction on direct and circumstantial evidence. And that jury instruction tells you that when you have two inferences, both of which are equally reasonable, one of which points to guilt, one of which points to innocence, you are to adopt the interpretation that points to innocence. That is, if both of them are equally reasonable. Now, in this case, at the point that Charles Kael is walking down Rockingham and is walking his dog and sees no Bronco on Rockingham, since he didn't look down Ashford, it is equally reasonable that the Bronco could have been on Ashford as it is that the defendant had already left in the Bronco. The inference that points to the defendant that's less inculpatory, that is less incriminating, is that the Bronco was on Ashford. Let's take that one. Okay? So let's infer from his testimony that when Mr. Kael was walking his dog, the Bronco was on Ashford. What does that tell you? It wound up on Rockingham. That's where it was found in the early morning hours of June the 13th. No one's disputing that. The Bronco was moved. And the inference to be drawn from that is that the defendant was out in the Bronco and he moved it. But you don't have to rely on just that inference. We have more. And what we have two things. As you may recall, Dr. Baden was the defense witness pathologist. He testified that the defendant told him that he had gotten cut when he went on the night of June the 12th, as he was preparing to get into the limo. He went to get the cell phone from the Bronco. That tells you the cell phone was in the Bronco. I'm going to talk about how he got that cut a little later. The cell phone was in the Bronco. That's where he had to go and get it from when he was getting ready to get into the limo. If the cell phone was in the Bronco and he's using the cell phone that night, he was out in the Bronco. And we have the proof for you in the form of the defendant's phone bill.
Twist, so
Your Honor,
defense
this
counsel
is
can see
People's
this.
403.
Right. Right. Thank you.
Okay. This is a little bit smaller. I'm going to hold it closer so you can see it. But this you'll have back in the jury room. Let me tell you right now, in case I forget, the exhibits that I use that I don't say a people's number for, you're not going to get those back in the jury room. So if you want to take notes or if anything will help trigger your memory from those that you want to make a note from, go ahead and do it because you won't have them again. Okay? Here's the exhibit that we marked during the trial. You will have this one back there with you. It indicates that the defendant made 2 phone calls on the night of June the 12th from his cell phone that we now know was in his Bronco at 10:03. Now, in terms of timeline on that night, what this tells you is that the defendant was out in his car at 10:03. Now, at that time, he made phone calls to Paula Barbieri. You may recall we heard the testimony of the, I think it was Llewellyn Robertson of AirTouch, and she told you, she interpreted the record for you and what it meant. And she told you that the calls were not completed, but we didn't need her to tell you that. The calls to Paula Barbieri were not answered because Paula Barbieri was in Las Vegas. She was not at home, either in Florida or in Los Angeles. She was in Las Vegas at the Mirage. You recall we had a witness testify to that. She checked into the Mirage at 2 p.m. on June the 12th. So she was not available to take those calls. Now, I think we have further corroboration for the fact that the cell phone was in the Bronco in the fact that Alan Park, the limousine driver, testified that he saw, as they were loading up the limo, he saw the defendant go out towards Rockingham, out to where we know the Bronco was parked, once or maybe even twice. So there is further corroboration for the fact that he went and got the cell phone out of the Bronco just before they left. Now, those phone calls are very significant in terms of their timing, because you realize that at 10:03, when he's out in the Bronco and he's made those calls, that the murders occurred about 10 to 15 minutes after that. So we'll talk more about the state of mind that he was in at that time. We'll do it a little later. Now, Kato, let's go back to Kato. He indicated that at about 10:15 or 10:20, and he's very approximate on these times. He's not looking at his clock. I think he readily admitted that to you. He made a phone call to his friend Rachel Ferrara, and that was a local call, so unfortunately we don't have a phone record to establish exactly when it occurred. This is an estimate on his part. Now, he testified, and I'm sure you recall it, that during that phone call, and he thought it was about half an hour after he made the call, he heard those thumping noises on his wall, very loud. So loud and so strong that the wall he was leaning on shook and a picture moved. And he said it was right in the area of the air conditioner that hangs over that narrow, dark south pathway. Those noises got him so upset, he suspected that it was an earthquake. He also told you he had suspicions that it might have been a prowler. And so he decided that he would go and see what might have caused them. And he told Rachel, he was scared and worried enough that he told Rachel that if she didn't hear from him in the next 10 to 15 minutes, to call the police. Now, he may have said it half-jokingly, but it's pretty clear he was worried. He was shook up. He was very shook up by those sounds that he heard, which is why he kept coming back to the issue, and he kept trying to talk to the defendant about it. And Alan Park, the limo driver. Now, let's talk about Alan Park for a minute. You remember, he was the young man who had never been to Brentwood before. So he decided to make sure that he wouldn't be late. And although he was not supposed to be there until 10:45 for this pickup to LAX, he left at 9:45 to be on the safe side. And you may remember that this was a witness who was absolutely neutral. Absolutely neutral. He was not going to strain to avoid answers. He was not going to make any effort to embellish anything. This was a witness who was just going to tell it straight and tell it honest all the way through, no matter who was asking the questions, myself or the defense. And he stood up there and he took the grilling for a very long time.